Hello, welcome to Current News. I'm your host, Chris Davis, and today we're going to talk about the Supreme Court upholding forced arbitration. So, last Monday, the Supreme Court, in a 5-4 ruling, upheld forced arbitration. If you don't know what forced arbitration is, it means that before an employee is hired at a company, an employer can require the employee to sign away their rights to pursue a class action lawsuit or forced arbitration. This has been said to cause a huge blow to employees, to the hashtag Me Too movement, because what a class action lawsuit did was it allowed employees to band together and sue an employer or the company for wrongdoing. And it was really great because the group could share the expenses of legal fees. But now that their right to a class action lawsuit has been signed away, they really only have two options. One, you can sue the company individually, but the legal fees will be very expensive, probably worth more than what you're suing for, which leads you to your second option, forced arbitration, which will be a lowball offer by the employer. The reason why class action lawsuits are more favorable than arbitration is because it's public record. The civil lawsuits, as I said earlier, you can share the expenses amongst your co-workers, but if you do forced arbitration, it's confidential. It's not going to be public record. It's going to be a take it what you leave it offer. This is going to hurt employees who want to argue for long hours and low pay, employees who are sexually harassed and abused. This is a very pro-business decision to help protect the employer, because class action lawsuits also hurt the companies because it was more expensive. It hurt the company's publicity, their image. Arbitration allows them to keep things private, so no one really knows about it. Just the whole process can be very skeptical because in arbitration there's 3 parties. So you have one party, like the plaintiff, and then the second one, the defendant. Then you have the arbitrator, the one who's supposed to be the objective one. But with these companies doing arbitration, is that arbiter, or the one who's doing the arbitration, the one who's doing it, is this person going to be objective? Are they going to be fair? Are they going to be on the side of the company? Is it going to be a panel of employees doing the arbitration? So it's a very skeptical process versus doing a class action lawsuit in open court for the public to see. Before the Supreme Court upheld this ruling, they were tasked to reconcile 2 federal laws that contradicted one another. The New Deal labor law allowed employees to band together and pursue class action lawsuits, while the Federal Arbitration Act encouraged arbitration instead of going to the courts. And Justice Neil Gorsuch, the one who was in favor of forced arbitration, with the 5 conservative justices, he said that the contracts are valid under the arbitration law. As a matter of policy, these questions are surely debatable, but as a matter of law, the answer is clear. In dissent, for the liberals, Justice Ruth Bader Ginsburg said that the decision is egregiously wrong, that the individual complaints can be very small in dollar terms, scarcely of a size warranting the expense of seeking redress alone. So that was like the liberals' view about it. So this decision is a pro-business decision. really comes for workers unionizing, wanting better pay. Just this past year in December, when AT&T offered to give their companies a $1,000 bonus, it wasn't because Trump's tax law got passed. It was because the union workers had already been working on that. So this upheld ruling is in response to that. It's definitely in response to the hashtag Me Too movement and women supposedly breaking their confidentiality agreements and going public and suing their employers for sexual harassment. This upheld ruling is in response to that as well, and the upholding of forced arbitration hurts all of those movements. Employees seeking for better hours and better pay, employees who want protection from sexual harassment. It hurts all those movements, and it's really a pro-business decision. And Justice Neil Gorsuch, the one who was appointed by Trump, who replaced Justice Scalia. Originally, President Obama was supposed to pick a justice, but the conservative Congress, Senate blocked President Obama's nominee and put Trump's nominee in there, and Trump's nominee is already doing his work for Trump, being pro-business, reversing President Obama's regulations that he put in place during his administration to protect employees. So that's all we have for today. Let me know what you think in the comment section below. Are you for class action lawsuits? Are you for forced arbitration? Let me know what you think in the comment section below. Also, if you want to follow me on social media, just go down to the description box, and down there I have my hyperlinks that will take you to my social media sites. Also, if you really want to help this channel, please hit the like button and subscribe, and all of you have a great day.